For people watching, we don't see you, but we know you see us, and thank you so much for joining. All right, folks in the crowd live, please take a seat. All right. Folks talking, maybe move to the side. Thanks so much. Thanks so much. Okay, here we are. We're in our research-focused panel. We're going to be a little presentation heavy in this panel because we want to give everyone a chance to talk about some of the data on bail reform. We've got 2 panels in the afternoon that are going to be moderated discussions on implementation after lunch and on the relevance of racial disparities and of conditions in the jails to this conversation. But we're here, this is the research-focused panel. My name is Mike Rempel. I'm the director of the Data Collaborative for Justice at John Jay College. I'm going to introduce the panel. We have Sandra Smith, professor of criminal justice at Harvard Kennedy School. Aubrey, there you are, Aubrey. Aubrey Fox on the other end, executive director of the NYC Criminal Justice Agency. Olive Liu, who works with me. She's a senior research associate at the Data Collaborative for Justice. Jayo Kim, associate director of research at the Vera Institute of Justice. And Jennifer Perrone on the end, associate research director at the CUNY Institute for State and Local Governance. Here's what we're doing. Sandra is going to kick us off because she has done research on bail reform nationally. So we're going to start by widening the lens. The other 4 speakers are going to then bring us back and share some of their key takeaways on the research in New York. We are going to make every effort to have time for Q&A. If you are sitting at home, you can participate in Q&A, but you're going to have to go to Twitter. Please tweet your question and use the hashtag NYBailConference, hashtag NYBailConference. Your question will be seen, and we will try to get to a few. If you're here in person, you don't have Twitter, there should maybe be index cards you can write on. If you have something to write on, someone will come around at the 45-minute mark, and we will try to collect your questions as well. Okay, I'm going to step back and do a minute of level setting, then I'm going to turn it over to Sandra. I know many of you watched the plenary. I just want to review New York's bail reform. What is New York's bail reform? What are we talking about? We're talking about 5 fundamental components that were put into the law. Number 1, bail reform is bail and pretrial detention are no longer permissible in most nonviolent cases. Number 2, supervised release must be available to judges as an option in every single case. But number 3, neither supervised release nor any other pretrial condition can be set unless someone poses a credible risk of flight to avoid prosecution. Number 4, even if there is a risk of flight, judges must use the least restrictive condition necessary for assuring court attendance. And number 5, judges, when they believe bail is the least restrictive condition, must still look at what people can afford before actually setting a bail amount. Okay, that's New York's reform, but as I said, we want to give a broader lens to the conversation, so I'm going to kick it over to Sandra on national research.
Thank you, Michael. Okay, there's a lot to manage over here. Let's see if I can do this right. Okay, so just to be clear, the research that I've done the research that I do, thank you, is primarily focused on the conditions of people's experiences in pretrial detention. So I study the conditions of confinement and also the impact that those conditions have on people. In order to understand that within the various contexts that I have studied the experiences of pretrial detention, I also have done this kind of landscape analysis with the assistance of an amazing research assistant that I have at Harvard, Isabella Jurgensen. And so I'm drawing from that, but also my work on people's experiences in pretrial to speak today, and look forward to the discussion later on about the conditions. So in 2016, several defendants filed a class action lawsuit against Harris County, Texas, for unconstitutional bail practices against people arrested for misdemeanor offenses. Specifically in O'Donnell et al. Versus Harris County, the plaintiff class accused the county of setting bail amounts so high that many were detained pretrial for no other reason than that they could not afford bail. To end litigation, the county agreed to reform its pretrial systems and practices to protect the due process and equal protection rights of individuals arrested for misdemeanor offenses. Among other things, the O'Donnell consent decree requires that most misdemeanor defendants be released immediately on their own recognizance, so without secured bail, that those ineligible for immediate release be granted a hearing and access to an attorney within 48 hours of arrest, and that when secured bail is imposed, not only should the amounts assessed be based on evidence of a defendant's ability to pay, but also that less restrictive conditions could not reasonably ensure that that person would show up to court for their hearings. The decree also established a role for an independent monitor to evaluate compliance, track the effects of new practices on relevant pretrial outcomes, and promote transparency by publishing regular reports on the progress of the decree. In March of 2021, 2 years after bail reforms were implemented, the independent monitor released a second of 2 reports. In it, they reported from analysis estimating the effect of bail reform measures and what those effects have on misdemeanor defendants' current and penal system outcomes. Specifically, since bail reform, while the average daily misdemeanor jail population has declined significantly, there have been no observed increases in recidivism rates among those released pretrial that would suggest a public safety threat. The report also addressed speculations about the effect that bail reform has had on spikes in violence. We've seen this across the country. The report says, as murders have gone up in Harris County, with this year's totals the highest in years, members of the public and public officials have understandably sought explanations. We have noted some public statements linking homicides to bail reform. However, we find no evidence that bail reform has led to an increase in homicides. And those who have asserted otherwise have not identified any data to support the assertion. Thus, the monitor's core findings were in line with the court's finding in O'Donnell that money bail does not meaningfully promote public safety or court appearance in court. There was a formal response by the Harris County District Attorney, Kim Ogg. It was swift and unequivocal. She criticized the monitor's recidivism-related findings and analysis. Based on her own office's analysis of the same data, she reports not only that bail reform led to substantial increases in recidivism rates, but also that increases in violent crimes were directly attributable to reform-related pretrial release practices. Speaking for prosecutors, for police, and for crime victims, she said, whose daily experiences were claimed to conflict with the monitor's recidivism findings, bail reform as presently practiced in some Harris County courts will continue to be a driving factor in the crime crisis gripping our community. Her message was clear. Harris County's bail reform experiment had failed. Money bail does meaningfully promote public safety and should be reinstated to promote the public, protect the public from further harm. So as a growing number, this I'm sure sounds very familiar to you, as a growing number of jurisdictions across the country have attempted to implement bail reforms, debates have intensified about the relationship between such reforms and crime, including and perhaps especially violent crime. Similar debates, for instance, have raged here in New York, where the backlash against bail reform has caused the state legislature to roll back key elements just 3 months after implementation. And now the governor has proposed further rollbacks to the law. So although largely driven by politics, these debates raise an important and timely set of questions. What role does pretrial detention and release play in producing or threatening public safety? Does pretrial release incentivize crime and drive up crime rates, including violent crime? Here you go, including violent crime, as many in law enforcement have claimed. Or, all things equal, is pretrial detention the greater risk to public safety? So here, we should probably think about how we're defining public safety. Typically, what we do is to refer to its protective function. What can we do to protect people from being harmed or from having their property taken or harmed as well? What I would argue is that we should take seriously an argument recently made by NYU law professor Brian Friedman. I think I've got the name right. Forgive me if I've misnamed him. Who argues that we need to broaden our understanding of what public safety is. And when we do that, we should include what it means to have people's basic needs met, right? And so when we think about the impact of pretrial detention, we're not only thinking about what impact it has on crime, that's incredibly important, but we should also think about what impact it has on the individuals who experience it and the communities that they go back to. So when we take this kind of holistic approach, we would come to a very different set of conclusions. But we should also define our terms in terms of bail reform. Here, when we think about bail reform, or when we thought about bail reform, Izzy and I, we thought about any policy change that was intended to reasonably, or could reasonably be expected to reduce the number of people detained pretrial. And of course, bail reform can do the opposite, but we were focused on making sense of these kinds of efforts in our landscape analysis. So what we find is that over the past, say, 20 plus years, a number of states, more than half the states in the country, have been engaged in some process of bail reform. In some cases, it's just, let's start talking about it. In other cases, it is much more substantial. It might look like what has happened here in New York or what's happened in New Jersey. So we see multiple, I'm going to have to go off of my computer for a little while. We see multiple states engaging in efforts, and we also see an uptick over the last 6 to 7 years in states engaging in these efforts. Many of these state legislatures have engaged in these efforts after city and county level bail reform efforts have taken place. And so you see in Brooklyn and Queens efforts going on for over 13 or so years ago, but in the state we only see efforts over the past couple of years. So huge uptick in the number of states that are engaged in these processes. And you can see with this map of the US, the states that are engaged. I can't help but to do this, so let me go. So no reforms are found at all in these states where you see the lighter color bars. And that's relatively few states, all things considered. And they're kind of located primarily in the South and the Northern Plains. Some states are taking preliminary steps towards statewide reforms and so haven't done it yet, but are certainly engaged in the process. Here are the states with this lighter color that are focused, where efforts are largely rooted in what's happening in cities and counties, and so not so much statewide. Statewide reform efforts that have been implemented, but then subsequently limited or reversed. We know that that's happened in New York. It's also happened in California, and we have some moderate forms in a set of other states. But what this shows is a kind of engagement in most states, I would argue, across the country, but what that looks like differs significantly. The examples of the efforts that they're making, we could probably categorize, and I want to think about this a little bit more deeply, but in maybe 3 different categories, where they're changing presumptions and also establishing rights so as to protect individuals who have been brought into the system. So presumptions that people are innocent, presumptions that you will be released after your arrest and or released on non-monetary bail, that you have a right to counsel, as has happened in Harris County, that there's an expansion of procedural protections for you once you are brought into the system so that you can have due process, et cetera, and that those will be taken seriously. That also is a part of what has happened in Harris County. And that there's a removal of the presumption of detention for some crimes. We also see that a lot of efforts have been focused on essentially curtailing judges' discretion. Judges can't just do many of the things that they have tried to do in the past. Some of that is through the implementation of risk assessment tools. Sometimes that's in combination with judges' discretion, establishing guidelines for what judges can or must consider when imposing bail, limiting situations where judges can impose bail. The list goes on. And then in addition to that, there are efforts to really kind of focus on the needs that folks who are brought into the system have, expanding social services through pretrial services so that people have access, but also a serious consideration about the extent and nature of the use of bail, generally speaking. So I think it's a good time to start thinking about what these buckets are of reforms that we've been seeing, but they have made a huge difference to varying degrees in different contexts, and that is what I'd like to talk about at this point. So there were conversations earlier today which suggested that bail reform can be linked causally to pretty poor outcomes, not just in New York, but possibly other places. But apparently New York is also unique, so maybe there's something about this unique and exceptional context that makes it so that bail reform has had a particular effect here. What the overwhelming majority of evidence suggests is that bail reform has had no substantial effect on crime or violent crime in multiple contexts. One of the things we can look at, and this is of no surprise to us, is the extent to which bail reform has impacted unsecured release. You put in place bail reform, various kinds of measures. It tends to increase the rate at which people are released without monetary bail, without cash bail. That makes perfect sense. It also tends to reduce the size of the jail population. We see this happening in multiple contexts. I'm just giving you a set of examples. In New Jersey, a reduction of 35%, 26% in New York between 2019 and 2020. The statewide decrease has been about 31% and about a 33% decline in St. Mary's County, Maryland. In New Jersey, I should be very clear that New Jersey's reforms were wrapped into a whole set of reforms, not just bail reform. And so some of that decline is probably rooted in some of the other measures that New Jersey took. And so we should take that into consideration. It's not just, though, about the unsecured release and the size of the bail population. We also see the impact that bail reform has had on how long one spends in pretrial, generally speaking, the whole experience of it. So not just detention, but from the point at which they were arrested till the case has been adjudicated. We do see increases in the length of time that takes. But that makes sense, because if I'm not being encouraged to take a plea deal so that I can get out of detention, which has a set of harsh conditions of confinement that would make me, it would have a really negative effect on almost every aspect of my life. So I'm not going to do that because I'm out. I'm going to take the time, as someone said earlier, to assess my options. I'm going to take the time to participate in the advocacy of my own case. I'm going to take the time to figure things out before I come to a determination. That takes more time. So the length of pretrial detention, or not detention, the length of pretrial, the pretrial period, we do see increase over a period of time. And this is a good thing, I think. The short period of time usually indicates that people are rushed into making decisions that in most cases don't work for them. But we also see an impact related on case outcomes. A significant decline in the percentage of people who are found guilty as a result of bail reform. Why is that? Well, because they're out, they're participating in their own cases, being able to assist in their counsel so that they can have strong cases put forward. And in the case of New York City, we also see a dramatic increase or significant increase in the percentage of cases that get dismissed. Time out to participate in your own case makes a huge difference. These are good things. And then we also see, this is the issue that is brought to us, the public, time and time again, dramatic increases in rates of crime, and especially violent crime. We're hearing about the horrible deaths the numbers of deaths that are occurring in Black and Latino communities, which oddly doesn't seem to lead to investments in those communities, their institutions, community organizations, but does seem to warrant us investing so much more in these harsh conditions of confinement and other penal practices. What we see time and time again with every rigorous study that I have seen is that there's no statistically significant increase in the rate of new charges, generally speaking. And when we do see small increases, in most cases, those can be explained away by natural fluctuations or end up being meaningless differences. This is the case as well with regards to violent crimes. No evidence that bail reform is linked to increases in violent crimes. There has been an uptick. We should be taking that seriously instead of using bail reform as the reason for why this is happening. The other thing that we should also be talking about, and I didn't have much time to talk about here, is the positive impact that bail reform has had. So mostly what we're looking at is the impact on crime, right? The absence of the negative. Great. But what we're also finding is that in some contexts, bail reform is associated with dramatically increasing rates of employment among Black men, closing the gap that exists between Black and white men in terms of employment related to bail reform. This is a recent study that just came out of New Jersey related to their bail reform practices. So we're seeing improvements in employment as a result of this, which connects very well with prior research that shows that pretrial detention has a negative effect on employment in the short and long term. Negative effect on being able to bring in your own income in the short and long term, right? Which speaks to the issue of how we're thinking about public safety very broadly. Because if you give somebody a job that allows them that pays a living wage, you're very likely reducing the likelihood that they'll come into contact with the criminal legal system. And this brings us to the issue of racial disparities, which will be talked about a lot later. We don't see bail reform having a big impact on racial disparities, or not in the way that we would want to. In many contexts, it increases racial disparities, in part because even as you see overall individuals, their outcomes improving, it improves much more for whites than it does Blacks or Latinos, right? And so we need to figure out how to jigger these policies in such a way, or their implementation in such a way, that has a positive effect on Black and Latino folks as much as it does on whites. This is what's happening in Kentucky. This is what's happening in Maryland. My understanding is this is what's happening in New York too. But we have seen some decreases in Harris County, and so that is an important context to pay attention to. Declining rates or gaps, narrowing of the gap, and people who are being released on bond. And so in the context where that is happening, it makes sense to study how it is that they're implementing and what the nature of that reform is, to understand how it could benefit Blacks and Latinos as much as it does whites. In terms of crafting effective and equitable practices or bail reforms, Isabella and I made a couple of recommendations in the paper we wrote on this topic, where we're suggesting that there's a presumption. There should be a presumption of unconditional pretrial release to recur within 24 hours of arrest, while unconditional release is not, in cases where it's not granted, it's important to require that these decisions on pretrial release be made within 48 hours. Why is this happening? And what can we do to get folks out as quickly as possible? This happens in the case of Harris County. Establish the right to an attorney at the bail hearing and throughout the process, where judges determine that release with no condition is insufficient. Require that the least restrictive conditions be met before applying cash bail. Pretrial release services must include providing text messaging to remind people of their court dates. Lots of evidence now supports the efficacy of this. It drives up people's appearance rates in lots of circumstances, and also provide wraparound services where needed. And then finally, include specific requirements for the collection, analysis, and dissemination of data. In most contexts across the country, the access to good quality data to make sense of what is happening, what kinds of factors impact what kinds of outcomes, is woefully inadequate. So for us to better understand what makes a difference, we need access to good quality data, and so each of these contexts should do the work to provide it. I will end there.
Well, I'll just start by saying thank you to John Jay and Arnold Ventures for inviting me today. And just a note about our panel moderator. Congratulations to Mike Rampell for his recent appointment to lead Data Collaborative for Justice. I couldn't help myself. So I'm going to try to do this a little more conversationally, but I will be showing you some pictures and some data from some pretrial dashboards that my agency, the Criminal Justice Agency, recently launched. And I think by way of context, what I want to say is this morning we heard, a pretty heated discussion at times with people with different points of view. But I think what stood out to me is a shared and sincere desire was for a trusted source of facts about what's going on with bail reform and our pretrial process of release. And I think that is absolutely a goal that my agency, by releasing these pretrial dashboards, of which there are 2 and a third coming, is trying to fill. And before I get into, I'm going to show you 4 pictures, basically, and tell you some stories based on the pictures about this process of what does it mean to actually create a trusted and shared source of data about bail reform. Just a quick note on my perspective and my role. So I have the great privilege of running the New York City Criminal Justice Agency. And one of the wonderful things about it is that we are both an agency known for research, but we're also an agency that provides pretrial services in New York City. So we have this dual role as both a researcher and a practitioner. And many of you may know this name. Jeremy Travis, our founding executive director, is the person who really encoded that combination of research and practice into our DNA, and we carry forward that today. So thank you, Jeremy, for that. I won't stop until everyone gets applause. Why did we do this work? I mentioned earlier that we wanted to try to provide a trusted source of information about pretrial release and pretrial conditions in New York City. But in some ways, the animating question for me was a really simple one. How many people at any given time are actually released pretrial in New York City? One of the things that I find really fascinating about sort of people in the know in criminal justice circles is that I bet most of you can get within 5 or 10% the question correctly: how many people are held in New York City jails right now? And we know the answer. Vera has a wonderful tool, the JailViz tool. Tells you there's 5,460 people yesterday held in New York City jails, of which 4,637 are held pretrial, right? Most people know that, I think, who are inside the system or knowledgeable of it. But what I realize is that no one really knows how many people are out awaiting the resolution of their case in New York City at any one time. That was the question I wanted to answer that started this journey of putting dashboards out. And as you'll see now, this is a live demonstration, right? You could actually go on the website right now and do what I'm doing. This is dangerous, right, if there's technical difficulties, but I'm willing to take the risk. So everything that I'm about to show you, you can do at home at nycja.org if you find our dashboards. So what does it tell you? In March 2022, a total of 40,323 people spent at least one day in the community awaiting their trial and pretrial release. And remember, that number of people in jail awaiting the resolution of their case was about 4,600. So obvious relationship between those two things. Judge arraigns a case, they can do one of two things. They can choose a release condition that either leads directly or indirectly to pretrial detention, or they can release someone to the community. So we wanted to bring a kind of human note to what does it mean to be in this community of people, not who are at Rikers or in jail, but who are actually been released in the community. And you'll see that in a sign, I think, of something that is quite healthy about our system. Ideally, you'd have as few as many people on pretrial release awaiting their trial. The number of people who, again, have spent at least one day in a given month on pretrial release has gone down significantly. In January 2019, you had over 57,000 people who meet that description. And in March 2022, you have about over 40,000. So that number has gone down. But one of the things that you can do with this data tool, which is actually quite powerful, is you can slice the data in a number of ways. And what we've seen, and I think people who are knowledgeable of the system will know this, is that essentially the bottom has fallen out of the system. There are far less people being released on a alleged misdemeanor charge than in the past. However, the number of people who are being released in New York City where the charge that led to their release is an alleged violent felony offense has actually gone up. So you have essentially, and this is sort of a meta theme of these dashboards, a changing pool of releases. It's not just fewer people, but a different profile of those people. So keep that in mind as we go through some of these slides. So, not slides, this is a live demonstration of the dashboard. Okay, so I wanted to point out something about the importance of pretrial practice in New York City. So I said earlier that there are about 4,600 people held in New York City jails awaiting the resolution of their case. Supervised release, which is one of the options that a judge has for releasing someone to the community, currently has, in March 2022, the most recent data that we have, over 6,000 people being supervised by supervised release. And Miriam Popper, who previously worked at Mokche, who actually led the expansion of the program citywide, gets a lot of credit for this. We have a program called Supervised Release that is literally supervising more people while they're awaiting the conclusion of their case than are held in New York City jails awaiting the conclusion of their case. And I want to just pause on that for a second, and I'll return to it in one of the later things that I want to show you. I said earlier that I'm a practitioner and a researcher, right? So a lot of the debate about bail reform tends to take the form of, is it good or is it bad? That's not how a practitioner can see it. We don't have that luxury. The question that we face is, given the people that we have to responsibly help and serve and try to encourage better outcomes for, what are the challenges that we face? So we don't ask good or bad questions. We ask questions about continuous improvement, nuance, and being very honest about what are the challenges that we face and how do we respond to them. Now, when I say that, that does not mean that I have taken a side in the debate about whether bail reform is good or bad. It is that I think about it differently because I am a practitioner. And if I had one sort of hope for the conversation about bail reform is that we pivot away from kind of op-ed style, is it good or is it bad type analysis, towards it is what it is, for now, likely. How do we build a better system of pretrial release and pretrial infrastructure? Okay, so I said I was going to show you a couple more pictures. This one is an interesting lesson in what I call humility about how an agency like ours produces data and how that data is consumed. So this chart has gotten us, quite frankly, in a lot of trouble, and I'm going to explain why. So this chart tells you, of all the people in a given month released pre-trial, how often in that month are they rearrested? This our dashboards have gotten a lot of attention, a lot of media coverage, a lot of people have cited them positively and negatively. And this chart is the one that has gotten the most attention. It's the same thing that was cited in our earlier panel, when a panelist said, before bail reform, about 4% of people were rearrested during the entire pretrial period. Now it's 5%. Okay, that is both true and false. The data does show you that about 96% of people released in New York City in that month were not rearrested before bail reform, and now it's 95%. Those arrests are only counted in that month. It is not the entire pretrial period, okay? Small differences in any given month can add up to larger differences over the entire pretrial period. Now, I don't think anyone has meant badly in taking a data point that only pertains to 1 month and citing it as the entire pretrial period, but it should be said that that is an incorrect representation of the data. And in fact, and we will be following up with a dashboard in the future that will make this clear, we have actually seen increases in pretrial arrest rates while out on supervision over time. Very complicated reasons, very complicated story. Is this the be-all and end-all explanation for increases in crime? Of course not. But again, as a practitioner, we have to live in reality. And the reality is that the risk pool of the population that we are dealing with is very different. So I'm going to end here. I don't have much more time. I said earlier that supervised release has now taken on a much larger caseload of people. And I've also said that the risk pool of people being released pretrial has changed. Part of that is because there are fewer low-level crimes, alleged crimes that are being brought into the court system. But another issue is the simple question of how often do people come to court carrying a case with them? So you're arrested, you're arraigned in court, you have an open case already. So the question is there a change in the percentage of times that people who are being arraigned by a judge carry with them a pending case? And to skip over a lot of complicated criminology, having a pending case is itself a good measure of the baseline risk that you will be arrested again, right? Simple concept. So what I want to leave you with is this, I think, fascinating visual representation of the kind of challenges that supervised release is facing. Full disclosure, my agency runs the supervised release program in Queens. So January 2019, about 29% of people who were assigned to supervised release at arraignment by a judge had an open case that they brought with them. Today, that's about 50%. So supervised release is dealing with, in this rough and not totally precise way, but still important to remember, a riskier group of individuals. And so my concern about the nature of the debate about bail reform, is it good or is it bad, is where does that leave a practitioner who has to say, how do I improve the program? How do I continue to innovate? How do I engage in a process of trial and error when the nature of the people coming into my program are different? We are left on the sidelines, unfortunately, when the only choice we have is to say whether bail reform is good or bad. So I do want, and I hope this dashboard is used as a way for people to engage in themselves in a more problem-solving and thoughtful approach to a very complicated issue. And just to leave you with the last thought here, I said earlier that we're both a researcher and a practitioner. This is what people who do both, this is how people who do both of those things think. And it's a requirement, I think, for us to build a stronger pretrial infrastructure, which is what created the conditions for New York City to release more people than any other jurisdiction in the country before bail reform. That is the infrastructure and the confidence and the orientation that allowed us to get there even before bail reform. And I think if bail reform is going to succeed, we have to maintain that perspective and use data to inform practice. So, thank you.
Good morning, or afternoon almost. I'm going to sit because these are readily accessible. So I'm Olive, Senior Research Associate at the Data Collaborative for Justice. And earlier this morning, President Mason had mentioned that we just recently released our latest report looking at pretrial release outcomes in New York State pre and post bail reform. So today, I'd like to share with you some key findings from that report. Okay. So in this report, we looked at felonies, misdemeanors, and violations that were arraigned in 69 city and district courts throughout the state. So pretty great coverage between January 1st, 2019 and December 31st, 2020. So in order to kind of set the context for the rest of our analysis, we first looked at what was coming into the courts over these 2 years in terms of the total volume of arraignments. So what we found is, if you look at the statewide graph over there, there was a 38% decline in arraignments overall from 2019 to 2020. And New York City had experienced the greatest declines compared to upstate courts and suburban New York City, which includes Westchester, Nassau, and Suffolk counties. So substantial decline in arraignments overall. And with our data, we had the luxury of looking at arraignments monthly, and we found that there was a substantial drop, again, in arraignments in the first quarter of 2020, so from January to April. And this, I'm sure you've already figured out, coincides with the onset of COVID, the closure of courts, and also, of course, the original bail reforms going into effect in April. So that was the context. But our report really was focused on looking at changes to pretrial release outcomes. So what are judges deciding at the point of arraignment when a person who has been charged appears in court? Are they deciding to release that person pre-trial, whether by ROR, which is release on recognizance, or non-monetary conditions? Are they setting bail for these cases? Are they deciding to remand, or are they disposing these cases at arraignment? So this is really the crux of our report. And we looked at this by geography, by charge, and demographics, which I'll take you through as we go along. So here, kind of the overall finding is that statewide, there was a 10 percentage point increase in the proportion of cases being released at arraignment. So the top purple line there. This is at the state level. New York City had the highest rate of pretrial release, both pre and post reform. And this isn't surprising, I don't think, since New York City has had pretrial release services in place for a number of years. And compared to New York City, upstate courts and suburban New York City courts were more likely to set bail kind of across the board over the study period. So just a couple of kind of estimates that we made in our report. We wanted to estimate what would the outcomes look like had this increase not happened? So had this 10 percentage point increase not happened? So a counterfactual, if you will. And we estimate that more than 24,000 more cases would have faced bail or remand in 2020 without that increase. And considering that people are only able to pay post bail in 20% of the time where bail is set, we estimate that the reforms contributed to approximately 19,000 fewer cases that would have resulted in pretrial detention. So, looking at charge severity, we found that the increase in pretrial release was especially evident among felony cases, increasing by, I want to go back to the last slide, but I don't know how to do that. One last thing that I forgot to mention here is if we just pause on that purple line at the top for a second, you see clearly that the increase in pretrial release actually started as far back as January of 2019. So, and the increase was pretty consistent up to about April when, a lot of things happened. Okay, moving on. So pretrial release increased by 17 percentage points among felony cases, and a corresponding 17 percentage point drop in bail setting. So this is for felony cases throughout the state. And just diving a little deeper into felony cases for a moment, I want to draw your attention here to the orange bars. So these are representing the proportion of cases where bail was actually posted. So bail was set and the person was able to post bail arraignment. So although we saw that 17 percentage point drop in bail setting for felonies, bail posting actually dropped as well over the study period. And what that means is that even though fewer cases were getting bail set, less people were able to pay bail. And this is especially evident if you look in the middle in suburban New York City, where the proportion of bail posting fell from about half of cases where bail was set in the first quarter of 2019 down to to less than a third by the end of 2020. And part of why that is, we hypothesize, or the data is showing us, is that even though we're finding that bail setting has declined overall and amongst felonies, bail amounts have increased over the study period, especially for felonies in suburban New York City and New York City. And just remember, in New York City, bail setting was actually much lower than the other parts of the state kind of throughout the study period. Okay, so we also looked at how outcomes vary by charge type, and just a couple of points to highlight here. One is that pretrial release for drug cases increased by 26 percentage points over the entire study period. And this was the greatest increase among all the other charge categories. And two, cases involving weapons charges, you'll see, had a much flatter trend in terms of pretrial release, and they were also much more likely to have bail set at arraignment compared to all the other charge categories, and this is pretty consistent over the 2 years. So if we just isolate the bail setting lines, there was actually a 4 percentage point increase in rate of bail setting for weapons cases. And then last but not least, we looked at variation of outcomes by demographics. Unfortunately, we only had 2019 race data for New York City courts, so we didn't have that for non-New York City courts, so we weren't able to do like a statewide pre-post analysis for demographics, but we were able to look at what was happening in 2020. So essentially, from these 3 points, what we found is that statewide in 2020, young Black men were least likely to be released pre-trial and subsequently most likely to have bail set. And then when we did do the pre-post reform comparison for New York City, we found that release rates increased by 3 to 7 percentage points for most of our demographic groups. But despite this, disparities persisted in terms of who was getting released and who was still receiving bail. So we found that Black and Latinx people were less likely to be released compared to white people, and especially when it involved felony charges. So a lot of findings condensed in a few minutes, but the key takeaways that I want to leave you with today are, first, that pretrial release was increasing pre-reform, especially in New York City. Upstate and suburban New York City courts were more likely to set bail, and this was pretty consistent throughout the study period. Bail setting did decline, though, overall, particularly for felony cases, but bail amounts increase, and this is likely contributing to people's reduced ability to post bail. Bail setting remained high and even increased for weapons charges. And then finally, racial disparities persisted post-reform in terms of who was released and who was still receiving bail. Thank you. So I'll turn over to my colleague Jay Oak, who's going to talk about bail impact on jail population. So.
Good afternoon, everyone. My name is Jae Kim. I'm leading Vira's New York Bail Reform Evaluation Study. And today, we at Vira, we conduct multiple research projects to understand how this bail reform in New York State is impacting the lives of the people in New York State. We conduct court observations to understand how the judges are implementing the bail reform. And then also we interview system actors, including prosecutors, defense attorneys, and also pretrial supervision officers to understand their perceived impact of the bail reform. And then the other thing is that we actually pay attention to incarceration trends to understand how this bail reform actually impacts the number of the people who are incarcerated in jail in New York State. So Division of Criminal Justice Services, or we call DCJS, provide multiple monthly jail population trends. And then here on the trend, you can see that from before in April 2019, about 21,000 people were incarcerated in jail statewide, and then majority of them were detained pre-trial. And then the jail population trend has overall downward trend, and then the largest decrease or substantial decrease happened in November 2019, which indicates that states and then counties started implementing the bail reform 2 months before the actual rollout of the bail reform. So in January 2020, about 15,000 people were incarcerated in jail. So about 6,000 less people are incarcerated in jail. And then obviously, as you all know, in March, COVID-19 pandemic hit. And then in July 2020, about 11,000 people were incarcerated in jail, statewide jails, which is only the half or 50% drop from the jail population in 2019. Unfortunately, this trend didn't persist. As you can see, in the latter half of 2020, the jail population started to go up. And we see the similar trends in both New York City and non-New York City counties. And then one thing that I wanted to mention here is that about 2/3 of the New York State jail population is actually coming from the non-New York City counties. So even though a lot of media attentions and conversation about incarceration trends in New York City, actually the New York jail incarceration trend is mainly driven by the non-New York City counties, and I think this is something that we should pay attention to when we are talking about the impact of the bail reform statewide. We also look at the changes in jail population by regions, and New York City as a reference, so about 37% of the jail population decreased from 2019 through by the end of 2020. And then you can see that Hudson Valley regions and Long Island regions, showed the largest, even greater decrease in jail population. More than 40% population has decreased in 2020. So the DCJS data provides the good overall snapshot of the jail population statewide. But for us to be able to understand what actually has changed after the bail reform, we need more granular and individual level data. And as you all know, New York City actually has a pretty robust jail data and then also other types of the criminal justice data available through New York City Open Data Source. But we weren't, unfortunately, the rest of the counties, rest of the state, we do not have that data set. So what Vera did is actually we reached out to all 57 county sheriff's departments and asked them for the data. And we received the data from 49 county jails, which covers about 86% of the non-New York City jail population. And so including New York City jail data, it covers about 91% of the jail population. So understanding the full impact of the bail reform on jail incarceration takes time. And then in addition to that, pandemic happened. So what we can do in the meantime is just exploring the immediate impact of the bail reform by comparing the incarceration trends in 2019 comparing it to the incarceration trends in early 2020. So the graph in front of you shows the average monthly admissions by chart severity. And then here, you can clearly see that more than 50% of the drop in jail monthly jail admissions in mainly misdemeanors and nonviolent felonies, but that drop is not as distinct and then not that much for the violent felony charges, which is understandable and expected given the bail reform legislation that was mainly targeting on the misdemeanors and non-felony charges. And we also see that the similar trends between non-New York City counties and New York City. We also looked at the likelihood of jail admissions after arrest, and then the finding is not surprising. We consistently see that more than 50% drop in the likelihood of jail admissions. But one thing that I wanted to address here is that depending on the regions of the arrests, so whether you are arrested in New York City versus whether you're arrested in counties outside of the New York City, your likelihood of pretrial detention after arrest varies substantially. So here, for nonviolent felony charges, for example, about slightly less than 50% of the nonviolent felony arrest resulted in pretrial admission in early 2020 in non-New York City counties. But compared to that, in New York City, only 11 or 12% of the nonviolent felony arrest results in pretrial detention or jail admission. So something that we have to pay attention to, these drastically different characteristics and the patterns in incarceration across New York. And then we're going to look at the changes in jail incarceration throughout the year 2020, just to see the prolonged impact and effect of the bail reform, as well as impact of the COVID-19 pandemic. We just divided these 2-year time periods into five buckets or the 5 bars. And then when you just compare the black bar to the gray bar, this kind of shows that after the largest 50% decrease in jail population after the bail reform, there was another 50% decrease in jail population after the onset of the pandemic, and then you see that the admission kind of goes up in the latter half of the 2020, but it kind of never surfaced the level of early 2020 jail admissions. And this is the result for the non-New York City counties, and then the other is, and then we see the same trend in New York City as well. So last point that I wanted to make here is that, understanding, exploring whether this bail reform actually has changed the racial disparities, the existing racial disparities in the system, and particularly in incarceration. Because one of the, consistent research findings in the criminal legal research is that Black and brown people are disproportionately more likely to be incarcerated in jails. And then we were curious to know, whether bail reform actually, contributed to the decrease in this existing racial disparities. And then, unfortunately, what we found is that overall, the fewer number of Black and brown people, and also fewer number of white people were incarcerated in jail after bail reform. Actually, the ratio of Black to non-Latinx white incarceration rate increased after bail reform. So in 2019, Black people were 5 times more likely to be incarcerated to jails compared to non-Latinx white people, and then this difference increased to 6 times by the end of the 2020, which is something that we should pay attention to as we are exploring the long-term impact of the bail reform and the pandemic. So just to summarize our research findings, the jail population decreased more than 30% from April 2019 to March 2020 in both non-New York City counties and New York City. And the likelihood of pretrial detention after arrest decreased by almost 50% for misdemeanors and nonviolent felonies. Still, more than 13,000 people are incarcerated in jails, mostly for pretrial detention, in December 2020. And also, when I checked the DCJS website, last month, about 15,000 people were incarcerated in jail statewide. And then lastly, the overall number of Black and non-Latinx incarceration decreased, but racial disparities persisted and have some evidence that it might have been widened. I want to end my presentation by introducing VERA's two jail dashboards, and one of them is something that Aubrey already introduced, so thanks, Aubrey. Then the second jail dashboard that I wanted to introduce is that, this jail visualization tool shows the number of the people in jail across New York State from 2018 to 2020, and it's updated every 6 months, and then it has more granular information about the people who are incarcerated in jails, including bails amount, and then length of stay, and then racial disparities, etc. So for those of you who are interested in looking deeper on this incarceration trends, please visit VERA's website to check out this jail dashboards. That's it for today. Thank you.
All right. Hi, everyone. I'm Jen Ferrone. I'm from the CUNY Institute for State and Local Governance. Thanks. And so some of my colleagues here presented data on outcomes since implementation of the legislation, and I'm here to talk about a process evaluation that ISLG is conducting around implementation of the reforms, and this is funded by Arnold Ventures. Oh, I went the wrong way. So to just share some important context just about this study before I dive into the findings, our goal here was to really document the process of implementing. This is a sweeping set of reforms, not only focused on bail, but as a number of the morning panelists talked about discovery, there were also many changes to appearance tickets, or called desk appearance tickets, here in New York City. So there were a lot, and of course, pretrial service ramifications as well. So there was a lot going on. And ISLG chose to focus actually on desk appearance tickets and discovery in particular in our implementation efforts. But given our conversation here, we wanted to share what we've been hearing from stakeholders about pretrial services and bail in particular. So the goals of our evaluation was really to explore the ways in which New York counties and criminal legal system agencies across the state adopted the legislative requirements. And this is really, a lot about how they operationalize those in practice. As a lot of the morning panelists talked about, the legislation was often vague in certain respects. And so really, what does that mean on the ground for the stakeholders and practitioners that ultimately have to implement it? And with that, documenting the successes and the challenges that these agencies and individuals faced, and also to extract larger lessons learned from New York's experience, and really thinking about New York as a model for other jurisdictions, because as Sandra noted, this is taking effect in many states across the United States. many states across the country. So in terms of our data, we participated in a lot of interviews in multiple New York counties, not just New York City, and really talked with various agencies from law enforcement to pretrial services to probation departments that ran pretrial services to public defenders and also individuals that were impacted by the criminal legal system as well. I do want to note that we did not talk to judges because the Office of Court Administration was not able to participate in the evaluation, so anything, talked about judges is really the perspective of the other stakeholders that we talked to. We also supplemented that with document and data reviews as we had available. So I was going to start here with some of the key findings around pretrial services in particular. And really this echoes a lot of what, Aubrey talked about in terms of pretrial services. And we're going to highlight a lot of the challenges, especially in the early days. This is an ongoing evaluation. So we are talking to stakeholders again about what's been happening, since the last time that we talked to them. But I do want to recognize that with all of the challenges that agencies have faced, they've done a tremendous amount of work implementing these changes. So I just wanted to note that before I dive right in with some of the negative things that we might have heard from people. So in terms of pretrial services, I think, a common theme across our process evaluation to date has been this kind of difference between New York City counties and counties outside of New York City. And this was very much exemplified when we were talking about pretrial service providers. This was an unfunded mandate. There were no additional funds available to counties in implementing this. And this was really felt by pretrial service providers, especially outside of the city, because a lot of them did have more limited infrastructures, did have more limited staffing structures, and so it was not as easy for them to implement some of the changes that were specified in the legislation. New York City, on the other hand, had already been engaged in this effort for a long time, as we heard. They had the resources available to them, and while they did experience a lot of challenges in kind of re-envisioning what their programs looked like, they didn't necessarily have the same challenges that those outside of the counties expressed in terms of their infrastructure, for example. Oops, keep going the other way. The second finding around pretrial service providers was really that there were a lot of uncertain expectations, and they felt that there was limited guidance provided to them by the state. And some of these expectations they felt were unrealistic, just given, again, their more limited infrastructure, the fact that there was not a lot of funding available to them to implement these changes. They did recognize NIAPSA as coordinating a lot of these efforts for them, though NIAPSA is not a state agency and it doesn't have any regulatory authority over pretrial service agencies. So while they felt that coordination provided by NIAPSA was helpful, they would have liked more and they craved more from the state itself. A common theme also coming out of our interviews was a lot of provider uncertainty about what to expect in terms of their populations, especially outside of the city. I think the city expected an influx of clients into their services, but providers in other counties across the state didn't know how the judges would necessarily interpret key aspects of the legislation and thought maybe there would be a lot of release on your own recognizance and not many referrals to supervised release, for example. And so it was very hard for them to tell exactly what they should plan for and what kind of client, what volume of clients they should expect in this instance. I have a lot going on here. So finally, in terms of pretrial providers, and Aubrey talked a lot about this, there was, adjusting to working with a different clientele. So there was this idea of an evolving target population, especially in the city, clients with more extensive criminal histories, clients that had greater needs, particularly in terms of mental health and addiction, and also clients charged with more violent offenses. And so this required really a new staffing structure. There was a big hiring effort in the city. And different staffing, different specialized qualifications. I also wanted to note here that there were concerns around net widening with respect to supervised release, and this was related a lot to those that were issued desk appearance tickets. Some providers expressed that they were seeing individuals with desk appearance tickets in their programs, which they hadn't seen before. And so this was a concern just given, are the resources being allocated appropriately for that population. So I did want to make that point as well. So in terms of bail and pretrial detention findings, and I'll go quick, I know I only have a few minutes, and I think, again, we heard this throughout the morning, and, Aubrey said it also, but participants largely subscribe to the spirit of the legislation. So the stakeholders that we interviewed in terms of law enforcement, prosecution, pretrial service providers, defense attorneys, they all subscribe to the goals and objectives of the legislation. They understood, what the legislation was meant to do. Though some of those stakeholders did feel that the pendulum may have swung too far in limiting discretion. And again, we heard that, I think, throughout the morning. That said, I did want to highlight a lot of the positive, aspects of bail reform and what public defenders and those impacted by the system told us when discussing the bail reform provisions in terms of it really leveling the playing field. And this is not something, again, that we hear a lot in the stories around bail reform, so I did want to highlight it here. Not only does it remove the economic barriers to release, but it also reduces the collateral consequences that individuals face that are coming through the system. They're able to be in the community. They're able to stay with their families, remain in, their ties to their employment and their community at large. They also have better case outcomes, as was discussed, so less harsh sentences. And also, there was a lot of discussion around plea negotiations as well. It removes the leverage in terms of that prosecutors have when someone is in detention during the plea negotiation process. And together with the discovery provisions, really allows an individual to think about the plea deal before they actually take it. And I'll talk about reducing racial and economic disparities in just a second. And then on the other hand, law enforcement and prosecutors definitely shared with us the perceived negative impact on community safety. Of course, this is a very, important issue and something that we're faced with every day, and what we're hearing in terms of the current trends. People felt that bail reform took the tools away from them in terms of being able to consider other things, and especially when it comes to those who they felt were cycling through the system multiple times. And, we see this reflected, I think we see those concerns reflected in some of the amendments to the reforms. But of course, it's a nuanced conversation and there's a lot to unpack there. So finally, with respect to bail reform, and I don't think this is a surprise, there were challenges securing buy-in, for the reforms across stakeholders. And I think, what we heard from law enforcement and prosecution in particular is that there was really, no victim's perspective in the way that the legislation was drafted and perhaps passed, and no voice at the drafting table for law enforcement and prosecutors. And so they definitely expressed that to us in our interviews. Also, I think any agency outside of the city really felt like a lot of the legislation was New York City centric. So a lot of the examples that were used in the legislation to ground the legislation were not necessarily applicable in an out-of-city context. And one example is just some of the logistical concerns around town and village courts, which often don't meet regularly. And so some of the timeline, implications weren't able to be addressed in those courts because they didn't meet regularly. That's just one example. And then just other implementation issues that we heard about was around the ambiguous statute language, which I talked about before, but certainly permeated throughout all provisions of the legislation. Issues with the charge eligibility, I think I heard it referred to as the bail bucket. So what is in that bail bucket versus out of the bail bucket on both sides? There were concerns perhaps it was too expansive, perhaps it was too restrictive. And there's also a lot of unintended consequences, that we might have to consider as well. And we've been hearing about some of, how would judges interpret certain pieces of the legislation in the courtroom. And then, finally, just this need for a culture shift. A lot of the agencies we talked to, talked about preparing for bail reform throughout 2019 so that they were ready on January 1st, 2020, though not all counties were able to prepare in that way. But, in order to make implementation a success, that culture shift really does need to happen. So finally, just wanted to end on, a quick note around eliminating racial and ethnic disparities. I think my colleagues kind of have already covered this on the stage, but something that did come out of our conversations with stakeholders was that this is definitely a recognized goal of the legislation. However, there really were they weren't necessarily intentional around disparities in the way that they plan for implementation of the legislation, and so we're not really seeing those impacts on the ground. As Jayok mentioned, we're actually seeing disparities increase at this time. So even though, some well-intentioned reforms, even though reforms are sometimes well-intentioned, they may actually exacerbate disparities, and I would urge stakeholders to consider ways that they might intentionally focus on disparities. And I think a lot of the charge-based decisions are probably driving some of that as well, because we know certain communities and charging practices are, centered on certain communities or disproportionately impact certain communities. And then finally, COVID was a whirlwind. Doing a process evaluation 2 months into our interviews, COVID happened. It shut down everything, and of course, it compounded implementation challenges. Courts just weren't in session. Timelines weren't in effect. So in order to get people to reflect on how things actually would have changed was difficult because it just wasn't the regular state of affairs at that time. So we're learning more now in our more recent conversations. So I'll end there. Thanks so much.
Okay, thank you so much, Jennifer. So I'm gonna keep everyone for about 4 minutes or 5 minutes, which I think gets to about our planned session length. Okay, first I'm just gonna say people are watching at home, and so planning this, I said, come on, if I got on Twitter 3 years ago, everybody is on, they're going to tweet questions. It's going to be awesome. We don't have questions on Twitter. So someone here is going to have to ask a question in a minute. But I'm going to give you a minute to decide you are going to raise your hand and ask a question by stalling for time. I want to digest a little bit of what I've heard first. I think we heard from Sandra about the research nationally, which mirrored the debate that we heard in the plenary session earlier, yet at the end of the day, what I heard was there's not evidence of a relationship between bail reform and crime. But then I think we also heard from Aubrey that it's a little more complicated. That doesn't mean nobody is rearrested, because there are rearrests. There were rearrests before bail reform and after bail reform. I want to cut to a few additional takeaways from what we heard next from Olive, Jayok, and Jennifer. Number one, bail reform achieved one of its goals, which is to increase pretrial release. I think we heard that clearly. But then we heard about some of the goals that don't appear to have quite been achieved. We heard that bail posting of people who face bail has not improved. In other words, even though I started at the outset with having to take ability to pay into account being a core element of bail reform, it doesn't appear that we are there yet. And then we heard from Jayok that while the use of bail, while jail populations pre-trial have not gotten back up to where they were in 2019, her data shows that there was somewhat of a reversal, and there was somewhat higher bail setting towards the end of 2020 than at the beginning. And then finally, we heard from a number of speakers that although reducing racial disparities was a critical goal of bail reform, it doesn't appear to have been consistently realized nationally. I think that's a point, Sandra, that you had observed, and then we had seen this in New York. And then finally, Jennifer indicated that in her process interviews, it appeared as though people weren't focused on it or weren't sure how to achieve it. So I want to just sort of flag those as conclusions reached and issues raised here, and then I want someone in the audience here to ask a question. So who's going to do it? Who have I got? Oh, great, someone's got a mic, okay. And then after that, I've got to give Miriam a question. Miriam, you're going to go next, and then it's a wrap.
Hi, so I have a question about data on and making assessments about the different kinds of release conditions. Do we have any data on that? If we don't, what do we need to get it? And basically, I'm asking because I'm a defender in Queens. How do I argue to a judge, or how do I and the DA argue over what the least restrictive means truly is, other than a judge's gut feeling about what to do?
Well, if you want data, we got it. So I would say go to the dashboard. I didn't show you as much of the New York City arrests filed with the court dashboard, which looks at, in any given month, the total number of cases heard by the court and the release conditions for that court. But specifically for your question, I mean, we provide not just supervised release in Queens, but we, as you know, we conduct a release assessment, which provides information to the court about the likelihood of return to court. And that release assessment relates to the recommendations of the intensity of supervised release, if that is so chosen. So there are, in fact, tools in court that I know you well know can be used, that some judges are more receptive than others. But I think there is an argument that can be made about the value of someone who has, say, a perfect score on a release assessment. If they're released, they're going overwhelmingly likely to return for all their court dates.
So I'll just speak to the non-New York City data. We do have that data. The data that we have allows us to kind of distinguish the different types of non-monetary conditions. We didn't do it for this report because if you look at the report, it's very long. But just to plug our work, our forthcoming kind of update on the first 2 years post-reform will dive deeper into the different conditions of release. So, yeah.
Just to add what Olive just said, Bureau Institute of Justice also conducted analyzed the pretrial supervision data. We received the data from 5 counties outside of the New York, so Albany, Broome, Erie, Tompkins, and actually it's 4 Ulster counties. So like we received the data from those 4 county probation departments, and then and also we conducted core observations, and then we see that the judges are setting these conditions of release. But like what we see from counties outside of New York City is very much different from what we see in New York City context. So for example, there is not much of the variation in terms of the different conditions that's imposed by the judges. And then the second is that, I think this is something that Jen kind of touched on it, there are concerns about net widening of the use of the pretrial supervision services, but actually the data shows that actually that's not the case, because the judges that are judges who were typically setting pretrial release were prior to bail reform were setting conditions of release on the charges that are no longer eligible for bail. So actually it's just a mandatory release, and then the judges stopped kind of utilizing this setting pretrial supervision services in that sense. So so that's the findings, and then we also have the report coming up in a month or 2, so yeah, stay tuned.
I'll try to be quick. In the Harris County context, and this is a slightly different kind of response to your question, judges actually needed training around how to think about the different restrictions, and they were also provided on a fairly regular basis, like it is a pilot study, fairly regular basis, the impact of different kinds of restrictions, so that they would come to feel comfortable doing the least restrictive because they understood that it wasn't producing harms. And so so what was required above and beyond just saying do the least, judges actually need feedback about what that looks like and under what conditions, and also constant feedback about what the decisions are doing with regards to the people that their rulings impact. And I think that has to be an important part of this conversation because it matters.
Can I just add one more, the last thing related to that? So when we conducted court observations in Erie and Broome County, and then we actually saw that how the judges are setting bail and like what kind of arguments are made or not made, and then what kind of arguments are made by the prosecutors and the defense attorneys. And then our research finding shows that actually 85% of the cases where bail was set, there's no discussion and then arguments about consideration about person's financial ability to pay, and also judges typically don't explain what the risk restrictive means for this particular case or for particular defendants, and then typically their decision is mainly based on the charge severities and then also the other safety concerns or dangerousness. I think it's a kind of hard touchy topic to mention about it, but we already know that that's what's happening in the courtrooms, and then that's what the general practice has been like, by the judges.
Okay, all right, so I totally lied. We had another hand there. I want to get to that. Let's have this quick question here, a quick answer, a quick question over there, a quick answer, and then we're done. But just to pile on, I'm going to ask another question that maybe no one will have time to ask, but I'm just going to ask it. And Jayok, it's based on your comment that you just articulated, and Olive on the research you presented. How, I'm not saying anyone should answer it, but it's a question. For researchers watching or for us on this panel, how do we, Jayok, talk about your finding that I think you said 85% in 85% of cases observed when bail was set, there was no discussion of ability to pay? Do we say courts are disregarding the law? Do we say something neutral, like maybe they considered it, but they didn't talk about it? And just how do we, as researchers, communicate this type of finding that appears to be contrary to an element of the law? Okay, I'm leaving that hanging, and I'm getting a question over here.
Yeah, I mean, I don't know if it's going to be an easy answer, but I know it was thrown out earlier, at least some statistics about like black on black crime being the reason why the system disproportionately targets black and brown people and why we find them in our jails. And so my question is really, and I've seen some of the research saying that the disparity still exists, and that in particular for felonies, white defendants are getting out on lesser bail or no bail compared to black and brown people. So as researchers, I'd like to know, how do you combat this black on black phenomenon, that's the reason why we have disparities in our system?
So some disparities are associated with higher rates of crime in Black and Latino communities. But if we were to examine every stage of criminal case processing, there's evidence to indicate that bias also drives what happens in terms of creating these disparities. So it's not just about the fact that these communities are, and we should ask questions like when it's reported that folks from some communities are more likely to be rearrested after having an experience with the criminal legal system. I think we should be asking ourselves why that is the case. Some communities are over-policed and underprotected. So of course, if there's a higher concentration of police in my communities that research shows is above and beyond the rates of crime that exist in those communities, then you should expect that there's going to be higher rates of arrest. And being arrested doesn't mean you committed a crime. Is an accusation, and part of what we're supposed to be here to talk about is the presumption of innocence and how you're supposed to deal with people who are presumed to be innocent. In a context where we know that there are serious issues with how law enforcement behaves, misconduct throughout the process, and that impacts disproportionately people of color and people from low income and poor communities. So I think all of those factors should be taken into consideration. When we think about higher rates of crime in some communities, I think we should also be thinking about other factors that drive it. Social dislocation, economic dislocation, where we're funneling tons of resources into law enforcement. We're not investing in those communities with regards to healthcare, with regards to education, with regards to parks and recreation, which we know dramatically reduces rates of violence and other kinds of crime. We're not investing in housing so that people are housing stable, in food, right? So if we were to shift our thinking about what is driving these factors and take seriously the role that bias does play in each stage of the process, I think that we can come up with different solutions.
Okay, we got to get everything for once. Yeah, we have the creator of New York City Supervised Release Program here. She raised her hand. Okay, Miriam, make a comment. Anything you've got, ask a question, and let's get a quick answer.
Okay, I'll make this very quick. So, Professor Smith, thank you so much for your work. I think, especially right now, really taking the conversation around bail reform away from anecdotes and away from sensational press has never been more important. My question on your data, in terms of, each of those states, their reforms happen at a slightly different time and, over time. And with New York, obviously, the big question, it happened at a time when it's just so hard to have an experiment because so many factors were thrown up into the air, including the time between hearings, the people being able to get to court and to have their hearings, and police enforcement changed during that time. I mean, so many things happened, and I'm curious if there's a way to pull apart the effects and be able to say, with crime and with hearing times, with trial length.
I think, thank you so much for the question, and I'd be interested in others' response to the question as well. I think it really is hard to pull out the effect of COVID. COVID just disrupted everything, so how do you address the impact? With regards to the question of bail reform, one of the important points I think both Olive and Jill mentioned in their talks was that jail populations were declining significantly in New York well before bail reform and COVID, right? And we saw with those declining rates of crime as well, right? It declined and then it leveled off. There was a point, I think probably 2019 or so, where we start to see upticks of something. But even if we focused on the New York context and went before COVID, we see dramatically declining rates of jail detention associated with, I'm not saying causal, associated with also declining rates of crime. It wasn't driving it up. Right? And we see other contexts. Look across the river to New Jersey that implemented reforms in 2014, or at least they started to, right? In multiple reforms, including bail reform, we saw dramatically declining rates of jail populations not associated with. So it is the case that reforms happen across the country in multiple contexts much earlier, but most of those reforms have taken place since 2015 or so. Right? And before COVID. And if you look in those contexts, we're seeing very similar patterns. And I think that, so if we were all over the place, I think we'd have a question about, okay, what's really happening here? But generally speaking, the patterns are all in very similar directions, even in including impact on racial disparities. So I take that very seriously. And the final thing I want to say is, not only has the evidence shown with these rigorous studies done by folks like my colleague at Harvard, Will Dobby and his colleagues, showing that pretrial detention, not only does bail reform, this is what I want to say. I've shared that most of the studies are showing that pretrial bail reform has the impact of, it does not drive up crime. This is what I wanted to say. Pretrial detention does. You increase the likelihood that someone will have future criminal legal system involvement if they have been detained, both at case disposition and 3 years after. So we know that detention does produce these poor outcomes that we're concerned about. And we're not finding evidence that bail reform, which reduces jail populations, does the same. That to me it's pretty, we should always look at nuance. I'm a sociologist, we get accused of too much nuance. But what we're seeing in terms of these patterns seems to be very clear to me.
Okay, thank you so much, Sandra. Thank you everyone for bearing with us. We're going to get back on schedule. Oh, yeah, I got announcements. We're going to get back on schedule at 1:20. It's going to be more of a moderated discussion. So if you're home, you've got to tweet questions or, get through to us, and we will ask your questions. We're doing moderated discussion, lots of questions at 1:20. For people here, there is lunch. Go to the moot courtroom on the 6th floor, room 668. If you are a John Jay student and want to talk more over lunch, go to the faculty dining hall, and there will be a moderated discussion for you. Thank you all for bearing with us, and we'll see you in a bit.